Everyone. My name is Corin Bailey. I'm chair for the evening. My job here is really just to ensure that things run along smoothly so that you can hear from those that you came to hear from. This public forum on a victim notification system for Jamaica is if it's brought to you by the Sir Arthur Lewis Institute of Social and Economic Studies. In collaboration with the Center for Criminal Justice and Security and the University of the West Indies. I want to give special acknowledgement to a few people, the Honourable Mrs. Justice Vinette Graham Allen, puisne judge, Ms. Paula Llewellyn, Director of Public Prosecutions, Ms. Claudette Thompson, Senior Deputy Director of Public Prosecutions at the Office of the Director of Public Prosecutions, Professor Lloyd Waller, Director of the Sir Arthur Lewis Institute of Social and Economic Studies at the Mona campus, representatives from the Ministry of Justice, Norman Manley Law School, and the Faculty of Law, as well as our panelists, who I'll introduce soon, and our online guests. We often hear cries of we want justice, and if you're anything like me, you're often wondering, what is this thing called justice that they're speaking of? What does it look like to them? And that's an important question because justice means different things from person to person. But more importantly, justice systems work differently among different jurisdictions. They have different goals, different priorities, and each jurisdiction's conceptualization of justice varies. But it tells a tale about the priorities of the decision makers as it relates to how justice should run. We in the Caribbean, we've traditionally seen justice as retribution for offenses committed. We within our system we punish offenders on behalf of society, and we traditionally have not seen the victim as part of that process beyond serving as witnesses, for example, after which by and large there's very little consideration given to them or their needs. But there's a school of thought that I myself subscribe to that suggests that for true justice to be served, the victim's concerns need to be paramount within that process of restitution, and that does not necessarily end when the person who has harmed them has been put behind bars. There are many ways to do that, and we're here today to discuss one such method of victim-centered justice, and that is where the victim is respected and supported in a manner that they need throughout the criminal justice process. So as I move things along, we're going to have opening remarks from Professor Lloyd Waller, Director of the Sir Arthur Lewis Institute of Social and Economic Studies. Prof. Waller.
Thank you very much, Corin. All protocols observed. Today we're here not just as individuals, but as a collective force united by our shared commitment to enhancing the justice system in Jamaica. This forum, a collaborative effort between the Sir Arthur Lewis Institute for Social and Economic Studies, SALISES, and the Center for Criminal Justice and Security at the University of the West Indies, underscores our dedication to addressing this particular pressing need of our community and our country. As we embark on this journey today, let us be guided by the spirit of empathy, justice, and innovation. The discussions and insights that will be shared today aim to forge a pathway to a robust victim notification system that upholds the dignity and the rights of all affected by a crime. The system is more than just a mechanistic structure. It is a pledge to those who have felt unseen, those who have felt, those who are unseen, those who are unheard, and those who are vulnerable. I urge each and you today to engage deeply, question constructively, and collaborate tirelessly. Let's draw on best practices, harness innovative technologies, and most importantly, listen to the voices of those we aim to serve. Together, we can build a framework, not just only one that informs, but also one that empowers and protects our citizens. Thank you for your commitment to this vital cause. Your participation today in this is a step towards meaningful change, and I look forward to the impactful outcomes that will undoubtedly be achieved today. Let us proceed with purpose and with the hope that we will achieve these goals. Thank you for coming here today, and I look forward to the discussions. Thanks.
All right, thanks, Prof. Our keynote speaker today is Honourable Mrs. Justice Vinette Graham Allen, puisne judge. She has over 40 years' experiences in the courts. Prior to pursuing her law degree, she held several positions in the Resident Magistrates Court and Family Court in Jamaica. She's a graduate of the University of the West Indies and the Norman Manley Law School, and was called to the Jamaican bar in October 1992. Justice Graham Allen joined the office of the Director of Public Prosecutions in Jamaica and rose to the rank of Acting Deputy Director before migrating to Bermuda in 2000. Justice Graham Allen was called to the bar in Bermuda and became the Director of Public Prosecutions in 2004 and served in that capacity for 3 years. On her return to Jamaica, Justice Graham Allen became the Director Principal of the Justice Training Institute, which was tasked with the responsibility for designing, developing, organizing, and conducting training programs in justice administration for legal and non-legal personnel. She was an associate tutor at the Norman Manley Law School before becoming the Director of Public Prosecutions for the Commonwealth of Bahamas in 2010. She's currently a member of the International Society for the Reform of Criminal Law. She became a member of the Jamaican Judiciary in January 2015 and is the Executive Director of the Judicial Education Institute of Jamaica, with responsibility for training of the judiciary and staff. Justice Graham Allen is a Fellow of the Commonwealth Judicial Education Institute, a member of the Board of Directors, and an Advisory Board member of the CJEI. Justice Vinette Graham Allen, floor is yours.
Justice Allen, remember to unmute.
Yes. Good afternoon, everyone. Are you hearing me? Hello, are you hearing me?
Yes, we are.
Yes.
Justice Graham.
Thank you. I will adopt the protocol that has been established in the interest of time. And I will go right into why we are here today. Our task this afternoon is to explore and develop a victim and witness notification system in Jamaica called Victim Witness Notification System. The background to this development: the need for an effective victim and witness notification system in Jamaica has gained increasing attention in recent years. Victims of crime, including survivors of serious offenses and their witnesses, have expressed frustration over the lack of timely and transparent updates on case progress, court proceedings, and offender status. The absence of a structured and efficient victim and witness notification mechanism has left many feeling vulnerable, uninformed, and unsupported. This public forum serves as a follow-up to the Witness Care Conference held in 2019, which highlighted key gaps in Jamaica's victim and witness support infrastructure and underscored the necessity for an improved system that prioritizes victim and witnesses' rights and well-being. Recent reports published by the Jamaica Observer have also reignited public discourse on the subject. The articles Step cousin victim notification system explores challenges victims face due to inefficiencies in communication between authorities and affected person. In the dark details cases where victims and their families are left uninformed about the release of offenders, exuberating their distress and security and safety concerns. Given these pressing issues, this forum has brought together key stakeholders to examine: 1, best practices; 2, challenges and innovative solutions to improve Jamaica's victim and witness care and justice processes. It aims to facilitate meaningful dialogue among policymakers, law enforcement officers, legal practitioners, victims/witness support advocates, and community leaders. Now, at the end of our discourse, the aim or the primary objectives of this forum are as follows: to assess the current state of victim/witness notification in Jamaica and identify existing gaps. 2, to discuss best practices from international and regional context. 3, examine challenges and barriers to implementing an effective victim notice system. VNS, explore technological and policy-driven solutions to enhance victim communication, case updates. And finally, to strengthen collaboration among government agencies, civil society organization, and justice sector stakeholders. First, I would like to address the first point, best practices. Then I will go to challenges, then innovative solution for including improving victim and witness care and justice processes. This is a comment that I make. This forum is very important because innovative solutions must be found to address this vexed issue. This is not the first time that this issue has been addressed or was considered. I recall reading the Justice System Task Force report by the late Professor Barry Shavans, and at 6.16 onwards, it spoke about improved treatment of victims. And when you have the opportunity, it's online, you may read it. So the attempt to address this VEX issue started a long time ago. I make this point: the court must uphold the constitutional provision that speaks to a trial being held in a reasonable time, which is defined as 24 months from the time the accused is charged. So that is why it is so important to address this issue and to have this forum today. I will begin now with the question. I'm asking questions and we'll answer them. Who is a victim? Because I find sometimes the definition is not clear, it is blurred. And we kind of use the names, in the wrong context. The definition of a victim is to be found, it is in our legislation, Jamaican legislation, but I'm going to quote an international instrument, a United Nations instrument, United Nations Human Rights Instrument. It's online. It is entitled Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, which was adopted the 29th of November, 1985 at the General Assembly, Resolution 4034. Jamaica is a member of it's a member a member of that resolution, was present. It means victims of crime, means persons who individually or collectively have suffered harm, including physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through acts or omissions that are in violation of criminal laws operative within member states, including those laws prescribing criminal abuse of power. A person may be considered a victim under this declaration, regardless of whether the perpetrator is identified, apprehended, prosecuted, or convicted, and regardless of the familial relationship between the perpetrator and the victim. The term victim also includes, where appropriate, the immediate family or dependents of the direct victim and persons who have suffered harm in intervening to assist victims in distress or to prevent victimization. That much I will say. I will go on now to access to justice and fair treatment that was mentioned. I think one of our opening professors or doctors. Victims should be treated with compassion and respect for their dignity. They are entitled to access to the mechanisms of justice and to promote redress as provided for by national legislation for the harm that they have suffered. We have some of those legislation in this very country. Judicial and administrative mechanisms should be established and strengthened where necessary to enable victims to obtain redress through formal or informal procedures that are expeditious, fair, inexpensive, and accessible. Victims, and I am going to stress this during my presentation, victims should be informed of their rights in seeking redress through such mechanism. I will pause there and invite you to read further these declarations, and I'll get right into my presentation. I am mindful that I only have 20 minutes. Who is a victim? I have also covered what are their rights. Let me now address why victims and witnesses fail to attend court. Now, you heard my bio read. I am now a judge and sitting in the court number 5, that is in charge of case management, getting the case ready for trial. This is what I've found. Victims do not attend or their witnesses because they are not kept informed of the outcome of the case each and every occasion that it comes before the court. So naturally what you find is that because they do not know the development in the case, nobody tells them. When the police officers go to find them at the last known address or call their telephone number, no answer, because that is not being done. Now I am going to move on to suggest some innovative solutions, and that is why we are here. I would submit that we consider greater use of technology in our business line as recommended in the Jamaica National Vision 2030 Vision Report. It is there. Laws are to be in place to enable the courts at all levels are in place to enable remote hearings for trials. Both the prosecution and the defense can apply to the court to have a witness or a victim give evidence from a remote location anywhere in the world. Once the criterion stipulated in the legislation, they are met, to the satisfaction of the court. So those are my observations. Those are my remarks. I would like to expand on exploring innovative ways of notification. When I say that everybody in Jamaica has some sort of phone or the other, we may want to consider if the victims are to be notified, whether we can use all those, whether emails, and I'm going to give you an example of what happened in the Commonwealth of the Bahamas, whether emails, and of course, you'd have to look at how secure the platform is, and I was reliably informed that it can be secured. Social media, consider using social media platforms. They are like WhatsApp, and they can be secured. And other medium, but the innovative ways is by communicating to the victims and witnesses, giving them an update. I won't say who should do it. I'm just saying that these are some of the innovative ways that we need to employ, and forget the old days where, and I'm going to talk about the laws that may need to be amended, and that is, I hope we have persons from the Ministry of Justice on the platform. Most times when I ask the prosecutor in court, were the subpoenas served on the victim? No, my lady. Why? I went to the address, I can't find them. I called the number, it's not in service. The witness our victim is not served. And so, because the case is to be tried in a reasonable time, which is 24 months from the date when the accused is charged, time starts to run, then when I look at the document on which they're tried, called the indictment, I will see like a 1998 or 1999 or 2015. And we embark on what is called a reasonable time chronology to find out how long has this case been before the court. And then I ask, the prosecutor may say to me, Judge, the main witness cannot be located. Why? They were not kept informed as the case progressed through the justice system. I recall as a DPP in Bahamas, we had a similar problem. And what I did was to have a meeting and solicited the help of the prosecutor and the police. And I asked them, would you accept notification by emails? I say, yes, because I don't like when the police them turn up at my gate. They don't feel secure. I make that point because I believe the time has come for us to look for innovative ways, and email is one of them I would recommend. The other issue that I wish to consider is accused is offered bail. You're in the supermarket doing your shopping. You're in the same corridor. And when you look, what isn't this man who chopped my daughter or alleged to have murdered a family member? Then they're out on bail, then nobody tell me. So this kind of situation needs to be addressed in the innovative system, and the right, bearing in mind the right of the victim. I told you about the definition of it. Now, witnesses, you may have a victim. Every victim is a witness. Not every witness is a victim. I hope you understand that. Victims at times may die, but most times you have a witness who saw what happened. So the witness also must be considered under this rubric of innovative change that we're discussing this afternoon. Sometimes when you have matters that cannot be tried in the lower court, the parish courts, when we had preliminary inquiry and the victims have to come and, the judge write down what the victims say and witnesses and send the case down. That has been abolished now, and we have committal proceedings. So the matter comes straight to the home circuit court. Most times it happens and they don't know. No one bothered to inform them, and usually that responsibility is placed on the investigating officer, members of the involved in that case. We now have what is called the police liaison officer and the prosecution liaison officer. When they appear before me, if one is not there, other is there, I will remind them that please, I call it a standard direction, please inform the witness and their victims, if there are any, of the outcome of the case today in court. The reason for that is that you keep track with the witness. If anything happens or victim, they can call you and say, listen, something happened last night. I've gone out of the island. So it is important to bear these things in mind. I don't know how much more time I have, but I would like to leave those thoughts to be deliberated by the members of the panel, the noble members of the panel. Thank you.
Okay, thank you very much. Much appreciated. So we have, 1 second. We have 3 discussants that will be responding to the keynote address. The first is Ms. Claudette Thompson. Ms. Claudette Thompson has 2 decades of experience as a prosecutor. Ms. Claudette Thompson's substantive post at the Office of the Director of Public Prosecution is that of Senior Deputy Director of Public Prosecutions. She has served in that post since 2018. Ms. Thompson has previously acted as Director of Public Prosecution between August 2 to September 6 of 2019 and April 2024 to January 2025. She was Clerk of the Court in St. Anne in 2004 before becoming Assistant Crown Counsel at the ODPP in 2007. Ms. Thompson has featured prominently in several high-profile cases, including the case that led to the conviction of the boss of the one faction of the Klansman gang and leader Tesha Miller in connection with the murder of former chairman of the JUTC, to name a few. Ms. Thompson is a graduate of the University of the West Indies, where she obtained a bachelor's degree in international relations. She attended the University of Wolverhampton in the United Kingdom, where she obtained a Bachelor of Law. And at the Norman Manley Law School, she obtained her certificate of legal education. We also have Mrs. Emily Staples-Kamer. I hope I'm pronouncing your name correctly. As a graduate of the University of Louisville, Emily began her first career as a technology consultant for local businesses in the Jefferson County area. Wanting to find a place to be long-term, Emily ventured out to find a company that supported a mission and focus of service, which would continue to provide a meaningful purpose to her career. As a result of this effort, Emily soon found herself in her current position as a client relationship manager, working for a Pre-Insight, a company based in Louisville, Kentucky, with an unwavering mission in serving crime victims and supporting various public safety efforts. In 16 years, she has worked with the VINE service. Emily has worked with 25 states across the country in supporting their VINE offender and VINE protective order and VINE court notification services. Emily also works with various government and law enforcement agencies to promote these services along with a myriad of other organizations. Emily currently works with the VINE program and is very excited to share the future of VINE. We also have Dr. Dacia Leslie, Senior Research Fellow at the Sir Arthur Lewis Institute of Social and Economic Studies at the Mona campus. Dr. Leslie is chair of the Crime Prevention and Offender Management Research Cluster, hosted by the Sir Arthur Lewis Institute of Social and Economic Studies. She has researched and published widely in the last 6 years on crime prevention and social justice. Her non-commissioned research focuses on the lived experiences of inmates, ex-prisoners, removed migrants, and their child dependents, to the intersection of her teaching focus, which is on development studies with a specialization in monitoring and evaluation. She's a 2022 UE Guardian Life Premium Teaching Award recipient, a Commonwealth Scholar, and lead rapporteur for the first Witness Care Conference to be held in Jamaica in 2019 under the patronage of the Office of the Director of Public Prosecution. Okay, we're going to begin with Miss Claudette Thompson and move on to Miss Emily Staples-Kamer and then Dacia Leslie.
Good afternoon, everybody. Let me begin by adopting Her Ladyship's definition of a victim and indicate that though we're here to discuss a victim notification system, the distinction between a victim and a witness is necessary, and you'll come to see why as I go further down into my presentation. Just to indicate that, and as Judge has said, not all victims are witnesses, though all witnesses are victims, whether they have suffered physical harm or emotional scars. Now, the ODPP Jamaica has a witness care officer. And for those persons who read the article, I believe that was made clear, a single officer. Now, this officer is tasked with engaging witnesses, not necessarily the broader group of victims. This single officer, while engaging with witnesses, is tasked with alerting them to their next court date, and Judge spoke to that. This single officer prepares them for court by way of orientation, and you may be wondering what that is. Well, the victim care officer literally takes the witness to court, to an empty courtroom, and orientates them with the space, indicates where judge will be seated, where the jurors will be if it is a jury trial or anticipated to be a jury trial, where he or she, the witness, will stand or sit in court, and where, most significantly, where the accused person will be. Because the witness needs to be prepared to the fact that this offender, this person who did he or she harm, is going to be, under normal circumstances, in the courtroom. Of course, we're at that stage in our history where not all witnesses appear in the same physical space as the offender, as the accused person. But even so, the witness needs to be prepared to face the person whom he or she is accusing. And the witness care officer goes through that process of orientation with the witness. The engagement doesn't end there. The witness care officer preps the witness to give evidence. And what do I mean by that? The witness care officer takes the witness through his or her statement, that statement that was given maybe 6 months ago, if we're lucky, sometimes 5, 10, 15 years ago, the statement that was recorded by the police. And so it is a refreshing memory exercise. The witness care officer is present at court. Sometimes the engagement is so intimate that the witness is unable or reluctant to give the evidence in the absence of the witness care officer. So intimate is the development of that relationship. and that single officer makes herself available as much as is possible to the witness. As recently as yesterday and the day before, I recall the day before, our single witness care officer was absent from work because of ill health, and the witness was somewhat reluctant to go into the witness box. And just this morning, I got a call again saying the witness care officer needs to be in court right away. The witness is awaiting her arrival. So even the court recognizes the usefulness and the reliance that is placed on a witness care officer. Now, the witness care officer provides consistency and familiarity. What do I mean by that? We work in a space, in an arena, in a time when Crown Counsel will handle a file this term and never see the file again. Crown Counsel will encounter the witnesses. Today, the matter does not start. The matter is set for a day in the future, and another Crown Counsel will have the file then. It means that the witness keeps seeing different prosecutors each time he or she comes to court. The witness care officer provides that consistency and familiarity that we're not able to provide via the prosecutor, but certainly through the prosecution service. So the witness care officer is that link from one prosecutor to another, one courtroom to another, one judge to another. So I say all of this to say that the ODPP Jamaica recognizes the value in having witness care and by extension, witness notification. We are mindful of it and we try to do the best that we can. But let's put things into perspective. There are 5 criminal courts at the Home Circuit Court. Any given week, there are no less than 5 matters fixed for trial. So there is at least one vulnerable witness in each case. So let's do the maths. There are 15 weeks per term. There are 5 cases per week, and at least one witness who needs the care and attention and continuity of the work of a witness care officer. We're talking about a witness care officer having to treat with 75 persons in a minimum of 75 witnesses in a 15 weeks term. And that's only for Kingston and St. Andrew. That's only covering Kingston and St. Andrew. Let's take it wider, because the Home Circuit Court, as I just said, covers Kingston and St. Andrew and sometimes St. Catherine. And then we look at the other 12 parishes. It is the same witness care officer who is expected to treat with those witnesses. From a low of 100 plus matters, Crown Counsel is having to deal with during a 4 weeks period to a high of anywhere from 300 to almost 400 matters in a parish like Westmoreland, Manchester, St. Catherine. So while we understand, appreciate the importance of the witness care officer, we crave your indulgence as well and ask you to appreciate the volume that we're dealing with and the shortfall that we're dealing with in terms of manpower. How do we deal with this shortfall? Well, the very Crown Counsel who is in court for a rotation, who is dealing with no less than 5 matters per week, and that's in Kingston, but who, when he or she goes outside of Kingston and turns up in Trelawney or Portland or smaller circuits, is dealing with, during a 4 weeks period, anywhere between 150 to 170 matters. Now you imagine having to reach out to at least one witness, having to care for at least one witness in 150 plus matters. Let's look at Westmoreland. which is teetering on 400 matters now. And Crown Counsel, while there in a 4 weeks period, is having to make contact with, engaging one witness per case file. So that is the volume, that is the situation that we're having to deal with when a prosecutor is having to treat with witness care, because we can't expand it to victim care. When you're talking about a witness, a complainant who is a witness in a case of rape or sexual intercourse with a person under 16 years, and this is your witness, and then you have the police officer, and you have the medical doctor, and you have the recent complainant. The trauma extends to other siblings in the very home. The trauma extends to the extended family members in the home. Imagine the single witness care officer having to give care and having to engage those other family members, which is why we have narrowed it down to witness care. We have narrowed it down from victim care, and you will have to forgive us for that. Now, I'm aware, and I heard it in the introduction of one of our panelists, that in the United States, there is VINE. There is this victim notification system. And when I did the research, the reading tells me that there is cooperation between the FBI, the U.S. Postal Inspection Service, the U.S. Attorney's Office, the different attorneys' offices, the Federal Bureau of Prisons, and the Criminal Division. The research also told me that this system is a computer-based system that provides information to victims of federal crimes. That is to say, the status of the offenders and their release date. We don't have that here in Jamaica. But I want to quickly say that as a prosecutor, and I know Ms. Lloyd is on the platform, and if she wishes, she can contradict me. But as a prosecutor, we tend to guard the relationship that we have with our witnesses jealously. So I see where there are all of these organizations, these groupings, these bodies that interact and engage witnesses in that other jurisdiction. I don't know that in our current climate, we would want these many other groupings of persons engaging and interacting with our witnesses. We guard that relationship jealously. And while we are guarding it, we are mindful of the fact that there are so few of us to engage them, and the volume of work is so huge, so great, but we still guard it. I don't know that we would want these other persons engaging our witnesses. Additionally, I have found that when you, even as a prosecutor, when you call a witness and you identify yourself, the witness in Jamaica is suspicious of you, suspicious of who you are and what your motive is, which is why the normal initial engagement is through the investigating officer. We ask our investigating officer to alert the witness that Claudette Thompson, that Tom Stokes, that Mary Jane will be engaging you. That the initial introduction is conducted by our investigating officer. So it is the investigating officer, the police officer, it is Crown Counsel who has conduct for the matter or of the matter during a specific period of time, and our witness care officer, and I'm going to emphasize our single witness care officer, who engages our witnesses. I will confess, I'll admit, we accept that we need more bodies. In fact, for those persons who read the article, I did indicate that with the volume of crime, and as a result, the consequence, the volume of cases that we're dealing with now, we would at a minimum need 15 non-prosecutors, 15 persons who are not going into court to prosecute, where their sole responsibility is to engage, interact with, provide information to our witnesses. It is a fact that not every single witness is reached or reached in time or given sufficient notice. Her ladyship said as much, that she, in her own court, when she makes the inquiries, her conclusion is that enough is not done. And I'm not in a position to disagree, but by way of explanation, it is because we do not have the manpower behind all of the activities that is required, why the persons are not all reached, or not reached in time, or not given sufficient time when we do make contact with them. So, in summary, we would welcome having more bodies whose sole responsibility would be to engage with, to communicate with, to update our witnesses. Technology, I agree, could be used. We could be sending out SMS messages, could be sending emails, WhatsApp messages, and what we're currently using, we could continue to make telephone calls. That is my input at this time. Until all of this is put in place, Crown Counsel, our witness care officer, and our investigating officer will do our best to continue to engage our witnesses. Thank you.
Appreciate it. Mrs. Staples-Kamer.
Thank you so much for having me here today. I am excited to talk about the existing VINE program and share information on how the program began. I also wanted to cover some of the highlights of the functionality of the system, while also walking through some of the national statistics and reach of the program that we have today. And then I'd like to end with some recommendations on how to implement a successful notification program. I thought that Justice Graham Allen did a great job summarizing the need to meet victims where they are with timely and transparent updates on court proceeding and events, as well as offender movement. VINE stands for Victim Information and Notification Every Day, and is an automated system that allows victims to opt in to receive real-time notifications on court events, as well as on offender movement, such as releases, escapes, and transfers. The VINE program began in Louisville, Kentucky, where our team is based out of, back in 1994. And it was created in response to a terrible tragedy where there was a lady by the name of Mary Byron who was living and broke up with her boyfriend, and he retaliated and stalked Mary and broke into the home where she was living with her parents. He held her hostage and sexually assaulted her. She convinced him to leave, and she immediately called 911. He was arrested within hours, and he was booked into our local jail system here in Louisville, Kentucky. Mary was told by local law enforcement, as well as the prosecutor's office, victim advocate, that she would receive notification if her perpetrator were to be released. Unfortunately, that system was a very manual system in the 90s, and it required coordination between the jail staff and the prosecutor's office. Her perpetrator was bailed out, and he was released and was out for almost 2 weeks without her knowing. Unfortunately, Mary was leaving her place of employment on her with family and friends, and she was warming her car up on a December morning. Her perpetrator walked right up to her vehicle and shot her several times, killing her immediately. Her parents were outraged, and they worked diligently with local law enforcement officials to look at how can we prevent this from happening again? How can we automate the system to ensure that victims are receiving the dignity and respect that they deserve? The system was up and running a year to the date of Mary's death here in Jefferson County because of the diligence of her family. Fast forward, the system is now available in 48 states. We just implemented the state of Maine this week. They were the most recent state to join this national platform. This past year, we celebrated the 30-year anniversary of Vine. In 2024, we had over 5.7 million victims and survivors register to receive timely information. We sent almost 22 million notifications to victims across the country. Our customer support center, who are victim service trained, they are available 24/7. Each state has their own dedicated toll-free number directly to this representative team. They speak over 300 different languages using a translation service. That team took over 650,000 calls from victims and survivors in 2024. Through our Vine platform, we were also able to connect over 257,000 victims to local and state service providers that are available to assist with services outside of notification. Vine is run through an interface where we directly communicate with whatever offender management system an agency is using so that we are accessing timely information on offender or case movement so that we are able to notify victims in real time. Our teams are monitoring those data connections 24/7 to ensure they are up and running as they need to be to support victims of crime. Victims have the opportunity to register to receive notifications. I heard a number of those mechanisms listed today through our panel. Victims can choose to register to receive notifications via any of these following methods. They can choose to receive email notifications. We have phone call notifications that are automated. We have text message notifications. We also allow for notifications to be delivered via mobile applications. And we also provide TTY for hearing impaired individuals. Victims have the opportunity to choose any or all of those different methods to receive those notifications in real time. Next, I wanted to pivot to recommendations on how to implement a successful notification program. Again, Vine is very technological driven. We partner with agencies that we are deploying our services in and work seamlessly through our project management team to ensure that systems are up and running, typically between 90 to 120 days after we start our project. We support these integrations not only through our client relations team, but also through our training and marketing programs that we have to support the success of the program. I am happy to be here today and can be available to answer any questions. Again, thank you for having me.
Appreciate it. Thank you very much. Desa?
All right, thank you so much, Chair. Let me start by thanking Justice Graham Allen for aptly setting the context for today's session and sort of putting forward a number of recommendations, which I absolutely support. I also want to thank fellow panelists for putting into perspective the realities on the ground. The reality is that with Jamaica having a murder rate in the vicinity of 52 per 100,000 population and a category 1 crime rate of approximately 195, per 100,000 population. There's no doubt that there's an urgent need to implement and formalize a victim notification system. That being said, my intervention here today will sort of center on the recommendations coming out of the 2019 Witness Care Conference, which, amongst other things, emphasized the need to develop capacity. Just a bit of a background for those persons just joining us. So in 2019, we had a witness care conference, which was held at the Faculty of Law here at the University of the West Indies, Mona campus, right? And we convened with the support of a number of partners, primarily Global Affairs Canada, with the support of United Nations Development Program, to sort of advance discussions on improving witness care within Jamaica's justice system. So we saw an event which brought together a diverse range of approximately 200 justice stakeholders, right, including legal professionals, government officials, CSOs, and international experts, to just share best practices and innovative solutions and policy recommendations. So the conference, amongst other things, it sought to address key challenges that you would have heard highlighted here today. And it sought to particularly enhance the experiences of witnesses within the judicial process. Now, some key recommendations coming out of that conference and the integrated strategic plan, which is available, freely accessible to the public, and it's on the SALISES website. I just want to highlight some of those because I find that those recommendations are still relevant. So it's good to, again, put those recommendations in the spotlight. So you would have heard our previous presenters speak about, you know, the need for a joined up approach, the need to coordinate. Emily would have spoken about the seamlessness of partnering with a number of stakeholders within the justice system. And so one of the recommendations coming out of the conference was the need to establish a formal witness care network. And I know the caveats raised by Senior Deputy Director about who interacts with the witness, and we can understand the need to be jealous over witnesses, right? But one of the things coming out of those discussions was the need to, have a structured multi-agency approach that in a way would, oversee the coordination. Somebody has to, take the lead as coordinator to implement witness services in Jamaica. And so this will necessarily involve designating a responsible agency to manage witness notifications and ensure interagency cooperation. Another recommendation coming out of the conference was the need for a case notification protocol. So we heard Justice Graham Allen spoke about strengthening the legislative and policy framework. So one of the recommendations of the conference was the need for a case notification protocol to be implemented. So the strategic plan proposed the creation of a sort of standardized notification system. It emphasized case progression, the need for, the notifications to be sent in terms of court dates and case outcomes. But one of the things emphasized at the conference was the need to outline clear roles for justice sector agencies in maintaining timely and transparent communication with victims, because one of the issues were that one agency would think that would have been done by the other agency, and then nothing happens. So the need for a lead coordinating agency, and then of course a protocol to undergird that. Now, Justice Graham Allen and Senior Deputy Director Thompson mentioned the important use of technology for real-time updates, right? We cannot deny the importance of that. But coming out of the conference, the emphasis was on the need to develop an electronic case management system, one that is integrated with victim support services. And such an integration would then allow automated notification via SMS, email, or a dedicated online portal to keep victims informed about their cases, but also suggest services to complement whatever it is their needs are at the time. Now, another key recommendation. So if we're talking technology, of course, we're going to venture in the area of AI and all of these things and the potential of AI to make things a bit more efficient. But a key recommendation coming out of the conference, whether we go the technological route or not, there's just the need to protect victim privacy and safety, right? So of course, strengthening the legal and policy framework is one way, but that would involve, an integral process in ensuring that victims' personal information. So this is a sort of low-hanging fruit. I know that we're moving towards greater digitization, but there are some things that we can do a little bit better now in terms of ensuring that victims' personal information is protected. And so this would include implementing secure data sharing protocols amongst justice sector agencies. We heard about the culture of suspicion, and we know that a code of silence is predominant in the Jamaican context. And so there would necessarily be a need for public education and awareness campaigns. And so the strategy itself proposed a public outreach strategy, like a sub-strategy, to be developed to inform victims about their rights. Of course, if and when we take steps to formalize and implement the VNS, we will necessarily need to have a few public awareness sessions about the system itself. Just notifying victims about their rights, the available support services built into the notification system, and the importance of their participation in the justice process. Of course, this can take many forms. We're here today because of Jamaica Observer's 2 articles that prompted, kind of put this important issue back into the spotlight. So media campaigns, informational brochures, and community workshops are some of the ways we can raise awareness. And of course, the University of the West Indies, who is a leader in this area, can, provide support where necessary. There would necessarily need to be training for justice sector personnel, and this is another recommendation coming out of the conference. It was recommended that staff across relevant agencies receive training in victim-centered communication strategies. So, all presenters would have made an attempt to draw a distinction between victims and witnesses. So these nuances are important in how we communicate. And so it would be important for there to be training for justice sector personnel, particularly centered on communication strategies, trauma-informed care, and the importance of maintaining confidentiality when engaging with victims. There's also the suggestion of establishing victim support desks in courts. Many conference delegates felt that this was something that could be done easily, not necessarily with any additional extensive financial or other support, but to establish victim support desks in the courts where on-site assistance can be provided. And these desks would kind of sort of offer guidance on case status, legal procedures, and available psychological and social services. I'm pleased to hear about the witness care officer, which would perhaps perform some of these functions currently. So I'm really grateful to the ODPP's office for taking this step following the outcome of the Witness Care Conference. But of course, there is the elephant in the room. We heard about the need to have at least 50 witness care officers. So there's going to be a need for resource allocation and sustainability measures to be put in place. So we would need to give careful attention to mobilizing necessary financial or other resources, but also kind of mainstreaming this into our annual budgets and plans to show local ownership of, you know, the commitment to improve the lives of victims and witnesses in Jamaica, and ultimately the sustainable reduction of crime in Jamaica. So these are some recommendations that I feel that they remain relevant, and if effectively implemented, can help to optimize the effectiveness of an implemented VNS. And it can also enhance the efficiency, accessibility, and victim-centered approach of Jamaica's justice system, while encouraging greater cooperation from victims and witnesses. So at the end of the day, the bottom line is victims should have access to timely information regarding their offenders, whether their offenders are being released, or just general information of their offenders' actions, anything that will affect their safety. And Jamaica will necessarily need to develop capacity to support the effective implementation, maintenance of a formalized victim notification system. So I'll leave that, I'll just end it here, and we can flesh out a bit more during the Q&A. Thanks, over to you, Chair.
Okay, thank you very much. And thanks to all of you that have spoken so far. I want to open things up to the online audience. We have 20 to 30 minutes that we can use for questions and answers. Can you guys raise your hands just so I can see them and call on you if you have any questions or comments? Not seeing anything yet, but okay, so while they're considering, okay, I'm seeing one. All right, let me not talk. Sherwin, go ahead.
Hey, good afternoon. Thank you so much for this, Professor Bailey. I don't know, can you guys hear me clearly?
Yep, we're hearing you perfectly.
All right, good. I came in a bit late, and I was really interested in the bits that I got with respect to the witness care program that you're developing. I might have missed, you might have covered it earlier, but what kind of provisions are made, especially if the witnesses are children, or is any provision made for that at all? And if there's any kind of consideration for psychological care, or any kind of traumatic interventions that would suppress the harm that probably would have caused, especially by children being witnesses to serious and violent crimes.
All right, anyone want to respond to that?
So child witnesses are counseled, supported by counselors in the Victim Support Unit under the Ministry of Justice here in Jamaica. These persons are trained counselors, psychologists, psychiatrists, and that support is available from the very day that the report is made until the child is well. However, well is defined. So even after the case is completed, whether there's a conviction or acquittal, the counseling continues until it is no longer required.
All right, I just want to jump in a bit here to talk about, some of the legislative and policy developments. In fact, coming out of the Witness Care Conference, we finalized some child justice guidelines, which provide minimum standards for handling child victims and witnesses and children generally in need of care and protection. Of course, implementation remains a challenge, but I just want to spotlight coming out of the research that we did leading up to the conference that, there is now an emphasis or growing emphasis on improving child-friendly justice courts. And so special measures such as video link testimony, they have been introduced in a Jamaican context to prevent re-traumatization of child witnesses. I see Tanya Chambers on the line. I know she's the expert in this area, and she has published on the topic. But, the Evidence Special Measures Act, allows vulnerable children to give testimony via pre-recorded statements or live video feeds, reducing, of course, their exposure to intimidation. But, of course, there are a lot of implementation challenges, inadequate safe spaces, lack of specialized infrastructure. These are some, areas that we need to look at. Yeah, just want to spotlight that.
Following on may I? So, Chairman?
Yes, you may.
Okay. Following on the conference in 2019, the DPP's office secured 2 rooms and they were outfitted for witnesses to give their evidence from a remote location. Under the very legislation that the previous speaker spoke to. I'm sorry, I'm not remembering your name.
Leslie.
Leslie, yes, thank you. So there is that facility. Ms. Leslie did speak to children who are vulnerable under that piece of legislation, the Special Measures Act. All children are considered to be vulnerable. And an application can be made formally in writing or not at all, but for Crown Counsel, the child having said that he's afraid, he or she doesn't want to be in the same room as the accused, arrangements are made for said witness to give his or her evidence from a place other than where the accused is. I have yet to see a refusal when an application is made. And in fact, I can think of cases where on the spur of the moment, everything was normal, but when the witness walks into the courtroom, adult or child actually, witness says, I'm not able to speak with the accused man in the courtroom, and immediately applications are made, arrangements are made, witness is taken somewhere else, on building or off building, and the evidence is heard. So there is that. I was earlier talking about the fact that the VSU plays an important role in the lives of witnesses and victims. VSU provides that support before trial, throughout trial, after trial. Additionally, and I couldn't be sitting here representing the DPP's office and not mention, the witness care officer provides that support as well, whether to child witness or adult witness. That support is provided as well.
Okay, thank you.
Sorry.
So I'm seeing a hand from Carrie Ann Davis.
Good evening, everyone. Thanks. So the question I have, well, I am excited for sure about the witness care program as a probation aftercare officer, and to take it even a step further. When persons are given periods of incarceration and with the benefit of parole, sometimes it is so difficult to get in contact with the victim or relatives of the victim. So if we have a registry, because it is so important to get the person's input, 1, 2, sometimes because probably restorative justice is not employed, persons are still angry So it's not, while we want to protect the victim as well, it's also important to protect the person who's coming out and is rehabilitated, because they cannot return to the communities that they're coming from. So the information is also valuable for the victim and their family or relatives of the victims, and it is also important for persons who are coming out on parole as well. So we could say, well, you cannot return to this parish or you cannot return to this space. So that information is also important for that population. So I thought I should throw that in as well.
Okay, thank you. I figure that's more of a comment, but does anyone want to respond to that? Okay. Emily, I had a question for you. What are some of the privacy issues that you guys have had to overcome? I'm just wondering what lessons could be learned in transferring such a system outside.
Yeah, no, great question. Can you hear me okay?
Perfect, yeah.
Great. Yes, so our team, obviously, we've been doing this for 30 years. I failed to mention earlier, we also provide the federal VNS program. And so all of our data, not only the offender data, but also the registration data, is all secured CJS, using CJS compliance guidelines. And victims through Vine today, in the majority of states that it is available in, can register anonymously. And what I mean by that is that as long as we have the email address or the phone number, we can get that person registered to receive updates. So we don't have to have a name or an email, or a mailing address. And so, that is configurable, and you could choose to have the victim input that information, but most agencies have opted for it to be anonymous so that we do not have to identify who that victim is that's registering.
Right. Sorry. Okay. Perfect. And what is the response from victims? I imagine, because I mean much of the research shows how beneficial the victim-centered approach is, how much more a part of the justice process they feel when they are included. Has that been tangible? Has that been the response?
Absolutely. And I think that's evident in the program reach that we have. And so victims are able to participate in the various criminal justice processes that they may not have been made aware of previously. For example, a parole hearing, right, that they may not have had information on, or a court event, location change, right, that they may not have been made aware of. So it's really empowering victims to be at the table because they have access to this information.
Okay, thank you. Daisy, I'm seeing your hand.
All right, thanks, Chair. Just a follow-up question for Emily before she goes. But also I want to support the point made by Carrie Davis. Of course, it's just a matter of emphasizing that while the primary goal of a victim-centered approach is to minimize re-traumatization, right, and ensure that victims receive appropriate support and justice, it also intersects with broader justice system objectives, including accountability, rehabilitation, and crime prevention. So it's not, even though we kind of centering the discussion on victims and witnesses, it does take into account perpetrators as part of an integrated and holistic approach to justice. Emily, I'm really curious about design and implementation, especially you gave us the history of how Vine developed over time, but I'm kind of interested in learning about some of the challenges or cultural barriers that you would have faced. It could be resource challenges that you could highlight for us. at the onset of design and implementation. If you can expound on that a little bit. So I know that things might have ironed out over time with the scaling up of Vine to other states. But when you just started, I don't know if you have that history or you came on or you were at the birth of Vine. But if you can just share with us some considerations along those lines.
Yes, that is a good question too. And so you brought up the point around resources. And so that has been an instrumental component of our implementations and ensuring their success. And so a lot of states and agencies have used the principle around stakeholder engagement and governance structures. So really pulling together those various agencies that are impacted by victim notification and victim services, and ensuring that they are at the table from the beginning to help design the functionality and the notifications that you want to make for victims and survivors and witnesses. And I would say that has been very, very important. The other thing is on the technology side, right? Because we are reliant on the data that is getting inputted into a system, I would say, culturally, or even just, looking at the different jurisdictions that we integrate with, some are very technologically savvy and others are not. And so making sure that the individuals and the systems that we're integrating with understand the importance of the timely data, that the data is accurate, because we are picking up changes in the data to trigger these automated notifications to end users. So I would say those are probably two key things. Again, the governance structure on the team on the ground who are designing and implementing and supporting the system, and then the technology component, and ensuring that the data integrity is there on the agency side.
Awesome, thank you. One last follow-up question. Does AI have a role in all of this?
Can you repeat that?
AI. Do you use AI in any portion of implementation?
Okay, not today. That is something that our organization is looking into specifically in 2025. But today, all of the data integrations are done by our interface design team. And so we do not have an AI component today, but it is something that we have been evaluating.
Thank you so much.
You're welcome.
Okay, thank you. I'm not seeing any more hands. Last chance to get a question or comment in. No, going. Okay. Alicia Dunkley.
Afternoon. I just wanted to know, where do we go from here?
I suppose anyone from the panel can answer.
All right, so SALISES is very much involved with many things involving the MOJ and the judiciary. So one of the suggestions that I hear in the pipeline is to have or to develop a victims policy for Jamaica. So that would kind of, align with the proposal to strengthen the legislative and policy framework. And I suppose, once we have that policy developed, we can always create an M&E system for that. to ensure that implementation takes place and implementation is monitored and evaluated so that we can produce reports and give the public some idea of what's happening in terms of targets and key performance indicators. But that's it for me. I don't know if any representative from the MOJ is here. I know there is commitment here. There is commitment in the room. There has been expressed commitment from the Witness Care Conference. So we have a room of committed persons sold out to, bettering justice in Jamaica. So there is commitment. I see DPP's hand.
Thank you very much. Good afternoon, everyone. I have listened with interest to what has been said, and at the risk of rocking the boat in the midst of all this academia, I heard what Emily had to say, but there is an elephant in the room in Jamaica culturally where I would like to call it a significant cultural aspect that we certainly as prosecutors have to wrestle with. And that's the question of the reluctant witness. The reluctant witness who, when we do get to speak to them, and we have to use a lot of moral suasion as prosecutors, and you try to identify why they are opting out of the process. And these are the witnesses who, even if it is that we had one of these really sophisticated programs to automatically by SMS and email, and certainly as prosecutors, if we have the email and we have the phone numbers, we try to use that to engage with the witnesses. But you do have a number of them who opt out of the process, who change their phone numbers, they change their addresses, and you do have the odd one who will take payment to look the other way and give the accused a lie. Even relatives of victims, and the relatives are going to be witnesses. So I believe that if you have, I think in St. Vincent they have it, and I think we need to move to that, like a victim charter or a victim policy, which can be transmitted through public education programs. Sometimes some Jamaicans are very culturally closed. You have the elephant in the room of the informer fidel culture. And, so we have to recognize this as part of the conversation. I think at the office of the DPP, I certainly would like to see, I remember the very interesting Witness Care Conference, and it is out of that day, sir, that we recruited a paralegal to be a witness care officer. And in fact, I even have a small witness care unit, and we cooperate and consult with the Witness Protection Program at the National Security Ministry. But we really, as Ms. Thompson said, we would really need about 15 paralegals. I think in England they call them caseworkers. About 15, just those persons to do that sort of work. And it would really be in conjunction with the digitizing of our files that is ongoing at the office of the DPP. So I think that is one for the future. I think in the short term, Mrs. Dunkley-Willis, we will have to see if we can craft a justification to the Ministry of Finance and the Ministry of Justice to get more posts on our establishment as it relates to even another 5 or 6 persons, so that with the continuous digitizing of our records, where we have everything in soft, that is there, it's computerized, we'd be able to, as we can do now in a small way, have our witness care officers constantly being connected to some of our witnesses, the witnesses who want to cooperate with the with the program. But I will confess that there's always room for improvement, because as the her ladyship did indicate, the police themselves, who are our eyes and ears on the street, they too sometimes are overwhelmed. You may not know, but I discovered it when I had to give a presentation at one of the big CIB conferences. A lot of our detectives or police investigators, they are not given data or credit on their phones to be able to keep in touch with a lot of the witnesses. It is through their own private effort in terms of their data or their credit. So it's their money, their salary that they have to use very often to buy credit to use to connect with witnesses. But by and large, especially in some of the high public interest matters, through the police, the prosecutors, certainly at the level of the DPP's office, were able to get an inkling and an idea of who are the potential difficult witnesses. I've had occasion to say, and I will say it in this forum, prosecutors don't keep witnesses in their spare bedroom. And in Jamaica, they have a mind of their own. They're very individualistic. Even with the best will in the world, you try to maintain that engagement. But unknown to you, sometimes, depending on where they are in their communities, there are things going on in the atmosphere that will persuade them to opt out of the system, irrespective of what you put in place. But I hope that one of these days, as we progress more and more and we evolve more and more in terms of digitizing, and if we get more posts on our establishment in terms of paralegals to be witness care officers, one of these days, long after I have left the office of the DPP, we will see a situation where we have a modified version of what Emily spoke about. I think we'd have to have a hybrid situation, because in my experience, and I think Claudette can bear me out on this, when I like to speak about being in the trenches in a way that a judge cannot be. A judge is sitting down up there, but very often there are things happening in the trenches that we cannot possibly indicate to the court in the presence of the accused. By the time you indicate, if you were to indicate certain things in the presence of the accused or their attorneys, you may hear, and it has been happening. Ms. Thompson, when she was acting as DPP, had to send a strong letter to the bar about it. And I know it has happened in other jurisdictions, because I know, DPPs in other jurisdictions have told me, where you will have, now listen to this, you will have a one eyewitness in a case. And all of a sudden you hear that the one eyewitness has an attorney. And somehow that attorney's name keeps coming up. And the attorney comes to court to indicate that the witness they present you with a document has signed a statement recanting or saying that they no longer wish to engage in the process and to give the evidence. And you look and you see the same attorney keeps coming up. And then you see the same justice of the peace. Well, I have instructed Crown Counsel that when they see that sort of thing, they are to immediately ask that the investigating officer investigate to see if there's any possible attempting to pervert the course of justice or anything like that. So you have these aspects to the whole question of witness care that we in the trade would know, but maybe a lot of you as academics would not know. So it's a multifaceted approach, I think, that we would have to take. modifying, maybe some modification of what Emily has spoken about on a much smaller level, hybrid approach where we increase the number of paralegals that we have, specially trained, who can, be attached to the office doing witness care. We get very good support from the victim support unit at the ministry, but public education, perhaps launching a victim charter and a victim policy, and in conjunction with that, a sustained public education program, which would indicate to the general public the importance of being a witness if you are a victim and you are still alive, and the fact that the state is prepared to do A, B, C, D, E to protect you, or that we offer these services, but you have to be in a partnership with us in terms of also maintaining contact. Not if you're going to change your phone number, or you're going to change your address, you get in touch with this particular number, which is connected to our office, or with the investigating officer, or with a number that the police have. So I think it's a multifaceted approach that we would have to take. And I thank SALISES for providing this opportunity for those of us who are in the trenches to be exposed to what happens elsewhere, and to see whether it would assist us taking this multifaceted approach, given the Jamaican cultural context that we have to operate in, to enhance the operational efficiencies and witness care in general, certainly in the administration of justice in Jamaica. Thank you.
Thank you too. Sherwin?
Thank you very much, Chair. I just want to say that I appreciate the contribution made by the last speaker there. She raised some very important issues, and I just wanted to zero in on that aspect. She touched on it a couple of times with the witness protection aspect of it, that contributes to those perhaps reluctant witnesses. The conversation has come up maybe once or twice or at the community level, and perhaps I don't know how much this report or the conference has covered, but I think it's a very good opportunity to begin having a conversation around that sort of witness protection. It's a challenge nationally, and perhaps there ought to be some kind of community or regional response to begin to address those reluctant witnesses. But I'm going to go through the report, and if I have further questions, I'm going to reach out to the persons who are responsible at the conference here. Just to introduce myself, I'm Sherwin Stevenson, the Program Manager for Crime and Security located at the CARICOM Secretariat, just to put it into context. So thank you very much.
Okay, thank you too much. Appreciated. I'm not seeing any more hands, and we have to I'm seeing one more. This will have to be the last, and then we wrap up. Ms. Nicholson.
Good evening, everyone. Are you hearing me?
Yep.
Okay. I just wanted to add a little to that last speaker in terms of the community effort, because I think, based on research that I have done, it's really a challenge with the community, because some of the community are deep rooted, especially in religious, practices. And some of these religious practices go against the grain of supporting the witness program and all these things that we are trying to do. So I think what would help is to continue to reach out to the communities to educate them as to the importance of why we are raising these witness programs, why it is important, and it is not going against their beliefs, but it is trying to help people to be human, to help us to support people, in order for them to survive. And I think that is very important, because I remember one time I had to deal with something, and they were telling me the reason why they cannot go forward was because of the teachings of forgiveness and why they should forgive the person and stuff like that. So it is very important that we look at those type of things and to make sure that what we are doing, it does not impact as though we are trying to do away with those things and that they are negative, but we are trying to help them to understand, yes, forgiveness is important, but looking after the victims and to have them stand up for when they are being treated unfairly is important. So I just wanted to share that. Thank you very much.
Okay, you're welcome. Thank you too. Okay, we've come to the end. This has been a very rich discussion at short notice as well. So we're very appreciative of the interest and the engagement that all of you have shown. I'd like to thank our keynote speaker, our discussants, as well as all of you in the audience for sticking around and engaging. Thank you very much, and look out for the next outreach from SALISES and the CCJS. Have a good night.
Thanks, Prof. Bailey.